Good morning. I'm Nick Owens. I represent Tennessee Farmers Insurance Company in this case, and I would like to reserve 3 minutes for rebuttal.
All right, sir. You may proceed.
May it please the court, the motions or the appeal today is based on the trial court's denial of the motion for judgment notwithstanding the verdict, and also the denial of the motion for remittiture. This is a pretty simple case, and I'm going to try to keep it simple.
That's a unique statement in this court.
I'm sure you hear that all the time.
At just about every case.
Yes, sir. Well, the procedural part of it, I don't see there's any need in getting into that. We obviously had a UM case where I represented the UM carrier, but we proceeded in defending in the name of the tortfeasor. His coverage had already been paid, and so essentially what happened at the trial was I tried the case in his name, and we admitted liability, and the plaintiff really did not put on much proof at all. They opted not to introduce any medical proof, even though they had taken a doctor's deposition. They introduced no medical bills, and the only people who testified were Stephen Davis, Sr., and Shatamara Davis, the mother. They testified about their own injuries, and there was a verdict rendered. The courts, I'm sure, aware, $10,000 for each plaintiff. There were 5 plaintiffs. We are not challenging the judgments or the verdicts rendered in favor of Shatamara or Stephen Sr., but we are challenging the others for the minors. And in our brief, we cited the law on this, that the plaintiff has the burden of proof at a trial like this to prove an injury. And interestingly enough, this is really one of the first ones I've had where the plaintiffs actually admitted, as it relates to their children, 2 of them, Stephen Jr. and Spencer, that they were not injured whatsoever. The testimony that we pulled directly from the brief, from the trial record, is that they had no pain. They only took them to the doctor to get checked out. There was no mention of any injury whatsoever. They didn't bump their arm. This is, again, as it relates to Stephen Jr. and Spencer. The kids were fine physically. That was what both parents said. And then, of course, as it relates to Jasmine, the older minor, her mother testified that she simply had an injury, maybe for some slight back pain for 2 days. So that's really the whole case there, as far as the proof that was put on for the injuries that the plaintiffs, that they alleged that they had. And of course, at the close and in jury instructions, I asked the Honorable Trial Court to dismiss the claims of the minors, but that was denied. And so after the trial, timely, we filed the motion for judgment notwithstanding the verdict and the motions for remittiture. And we didn't even really get to argue that. We just got an email back saying that they were denied, and it was just like a 1-line email. So we are here because of that. We appealed 2 days later. I've cited the case law that really it's the everybody knows it, the Overstreet versus Shoney case. It talks about pain and suffering, encompasses the physical and mental discomfort caused by an injury, and there has to be an injury sustained by a plaintiff to recover. And so in this case, since the proof from the parents is that Stephen Davis Jr. and Spencer Davis did not sustain an injury, did not have any pain, there is no basis for any award for them. Now, as for Jasmine Lyons, there is proof in the record that from her mother, and again, this is kind of one of those weird situations where you have a child involved, and so the parent, can testify for them. But it came in that she had some pain for 2 days, possibly slight pain, and that she fully recovered. And so with that, the law talks about when a remittiture is appropriate from our viewpoint, when you look at the case law on remittitor, a lot of times it's like a multiplier of medical bills or that type of things that are looked at. And of course, you don't have any medical bills to look at in this case. But when, as far as the standard on that, the question is whether $10,000 award to Jasmine Lyons exceeds the uppermost boundary and range of reasonables under the evidence presented at trial. It seems to me that, we didn't really get any finding from the trial court, but as we are here today, it seems like $10,000 is way excessive for such a minor injury for her claim. And so what we're asking the court to do in this is to find that as far as Stephen Davis Jr. and Spencer Davis Jr. are concerned, the court should find that there is no evidence to support any verdict whatsoever for them. And then, of course, if the court did find somehow that there was, which I haven't seen it, then I would say then we'd move on to the remittitor as to all three of them. And again, you would look at the weight of the evidence that was given at trial, and it far exceeds the boundary of reasonableness when you could look at what they actually proved at the trial.
So
Now, yes, sir.
let me ask you a question here.
Yes, sir.
Sort of a procedural morass, I suppose. You didn't file a motion for a new trial.
No, sir, I didn't intentionally.
Okay. And I understand the reasoning in that, but when the trial court examines the motion JNOV, does the trial court, from the perspective of the trial court, does the trial court look to ascertain whether the trial court approves the verdict as the 13th juror as well? In other words, does the trial court go through the same analysis for a motion for new trial?
Your Honor, to answer that question, I've got I've cited the law on it, but I think the question is whether there's any proof to support the verdict.
Well, what I'm trying to ascertain is whether the trial court approved the verdict as a 13th juror.
Oh, I think they're two different standards.
I think there are too.
Yes, sir.
And that's what I'm trying to figure out, is does the trial court necessarily have to review it the same way when it considers a motion JNOV as it does for a motion for new trial?
Well, Your Honor, with the 13th, I'll be honest with you, I don't know the answer to that question, but I can tell you that in looking at the JNOV, the question is just, is there any evidence to support the verdict? So what we've done is from our viewpoint, there was a verdict rendered for each plaintiff. They just happened to all be related. And so our contention and what we've attached or attacking is the verdict insofar as it relates to the three minors, the verdict.
Sure, I understand what you're doing.
Yes,
I'm just trying to answer the procedural question, because I think the analysis could be affected here in that, has this trial court approved this verdict as a 13th juror?
Well,
if it has done so, I think that you've got to appropriately credit the trial court for doing that analysis.
Well, Your Honor, we didn't get an oral argument or actually get to go in and do any discussion, and there weren't any findings by her. All we got was an email saying the motion was denied, so we entered an order saying that it was denied.
Well, you're not contesting that process here today, are you?
Well, I didn't. No, sir. No, sir.
Okay.
I wanted to be as honest and answer your question as best as I could.
And I appreciate that.
Yes, sir.
I'm trying to work through this procedurally, because I think you don't see a lot of, although we've seen two in a row here today, you don't normally see a lot of JNOV issues in the appellate court.
Yes, sir. I understand.
I'm wondering, can we infer that she denied, that she approved the verdict as 13th juror from the fact that she denied the judgment NOV?
Well, I can't speak for her. I don't know, but what I can say is, even regardless of which standard you look at today, there's ample reason and basis for for Stephen Davis Jr.'s to be remitted to Spencer Davis's to be, Stephen Davis Jr.'s to be just completely wiped out. Spencer Davis is completely wiped out. And then for Jasmine Lyons, I think that what has to happen on hers, if the court finds that it is outside the bounds of reasonableness and it's totally excessive, that it has to be remanded with an instruction that it's too much. And then she has to take a look at it, the trial judge does. So I hope I've answered the question there on that. But I know I only have 1:15 left, but I did want to point out that in the appellee's brief, there are statements in there that the parents testified about the minor's pain, observations of the children's pain. There are references to this in their brief, which in the entire record, there is no such evidence. Again, I did my best to cut and paste from the trial record, and everything in there, the plaintiffs are saying that their children were not injured and felt no pain. And so here we are. I believe we're in a proper place where the court could wipe out Stephen Davis Jr. and Spencer Davis's verdict and then remand the case if the court finds that the verdict of $10,000 is excessive for basically a day or a day and a half, whatever, of some minor pain. And that's what we're asking that the court do. Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the court, my name is Elisa Tate, and I represent the appellees, Stephen Davis, Shatamra Davis, and their 3 children. I feel like, as we've already stated, this is kind of a straightforward appeal, even though Your Honor has said that that's not always the case when we come here to the Court of Appeals. But
just to go back to what Mr. Owens was just talking about, where in the record will I find any testimony of the parents that these children did experience any pain?
Your Honor, I looked this morning and I found that the testimony was that the children were frightened, but I do not see the testimony that they experienced pain, and that's an oversight on our end on that.
By an oversight, you mean the incorrect statement in the brief?
Yes, Your Honor. I looked that up this morning, and
Did you sign the brief?
I did not. Mr. Reeves signed the brief.
Go ahead.
Yes, Your Honor.
Well, let me ask you, the statements in the brief that the children suffered pain, did they cite to any portion of the record?
I don't believe that it's cited to the record in that. I went back through just verifying everything, and the mother talked about how frightened they were, and they did take the children for medical treatment at the emergency room.
But there was no testimony as to medical bills that was presented at the
There was
trial.
nothing as to medical bills, and I think that's where the mistake came from, because they did go for medical treatment with the children. Now, the parents had more extensive treatment, but they did take all 3 of the children for medical treatment. And then the oldest child, who was an adult at the time of the trial, she did have pain, it was stated through the mother's testimony, for a day and a half, and that's why I think that came from.
And Mr. Owens stated there was a medical deposition taken in this case.
That is my understanding,
And
yes,
there was a
ma'am.
strategic decision made not to present
I
that testimony.
believe that is what it was, yes, Your Honor.
Okay, did you try the case?
I did not try the case, no, Your Honor.
Okay.
So, one thing that I did want to speak on with the judgment NOV, that judgment NOV request was made, and the judge ruled in our favor. But as I reviewed the record, I don't see where there ever was a request for a directed verdict. And in the transcript, there's language that they asked that medical claims not be looked at, but I believe that it's, we've got to have the request for a directed verdict before we even get to the judgment NOV. So even...
You're saying you reviewed that and it's not in the record?
Yes, Your Honor, I read through the transcript, and I did not see where there was a Rule 50 request for a directed
At the close of plaintiff's
verdict.
proof, there wasn't a motion for directed verdict.
Excuse me?
At the close of the plaintiff's proof, there wasn't a motion for directed
I
verdict.
did not find it, no, Your Honor. And since, when we look at that judgment notwithstanding the verdict, the court has got to make that strongest legitimate view of the evidence in favor of the verdict and allow all reasonable inferences. So we believe that this is a very, very high standard, and that the judgment notwithstanding the verdict being denied was proper in this instance. There was evidence at the trial of the photographic evidence of the state of the vehicle. The jury saw those photographs. This was not a tap. It was a rear end of one car pushing another car into a third car. So the jury was permitted to infer physical injury from the severity of the impact. And we did only have lay testimony, but in Tennessee, lay testimony of pain and functional limitation is permitted. In our case, and the appellants have not denied that both of the parents described their pain and suffering, and they testified about the way that their children were frightened after the crash. So we believe that we have evidence, even though the plaintiff does say there's no medical evidence, and there's not. We do have lay evidence. It is disputed evidence, but it still is evidence in and of itself as to.
Wait a second, what do you mean by disputed evidence? I thought Mr. Owens said that they conceded liability.
That's exactly it. I'm just saying that we
So
did have.
They weren't disputing that the car was in a wreck.
They did not dispute that it was within a wreck, in a wreck, but they are disputing the level of the damages suffered by the children, namely, especially the daughter Jasmine. They are saying that.
Well, I get that, but they're not disputing the level of damages to the vehicle, are they?
No, they are not.
Oh, okay.
They are not. Forgive me for that, Your Honor. But we believe, again, that the law in Tennessee is clear that we are to give that great weight to what the jury determined in this case. The jury determined that it was a good verdict, that these people suffered, and they awarded them accordingly. And I think that as far as the remitter should only be appropriate when it is outside of the range of reasonableness and shocks the conscience. And I believe that the jury was proper. They were able to ascertain from what they heard that the damages and the injuries suffered by Miss Jasmine Davis, Jasmine Lyons, I believe that they felt like it was, that $10,000 was valid for her. And we believe, again, that the court did not err. They operated within their discretion. I do believe that there was no directed verdict asked for, so we don't even get to the judgment notwithstanding the verdict in this case. Thank you, Your Honors.
Thank you.
Mr. Owens, did you ask for a directed verdict?
Good question. The words directed verdict did not come out of my mouth. But what I can point to in the record right now are several instances where I asked that the court dismiss the minor's claims. So I know the court focuses on substance over labels. I did not say the word directed verdict, but in ask, I will point to page 77 of the trial record where I explained to the court they don't have the requisite proof for the jury to be able to determine that their claims or injuries were caused by the accident.
What point in the trial was this?
This was at the close of their proof. We did
Okay.
not put on any proof, Your Honor.
Okay.
And then also, Your Honor, on page 78, I said, I'm not arguing with Your Honor, I'm just putting it down on the record, put it on the record. I believe they haven't proven met the requisite elements of their case. I understand, Your Honor, deny my motion, and I respectfully understand, and the court said it's denied, thank you. And then going to page 93 of the transcript, I said, Your Honor, here, the minors' claims here, the problem I see with this instruction talks about medical bills they experienced and the pain they experienced, but the testimony is there was no proof of any medical bills for the minors, and the testimony was that Stephen Davis Jr. and Spencer had no pain. So therefore, I believe there's no claim for the jury to even, there's nothing for them to even be awarded in the case. They should be removed. And then again, on page 96, I explained that's why I moved their claims be dismissed. They didn't prove any damages of at least SD1 and SD2. That's Stephen Davis Jr. and Spencer Davis. They got no medical bills, and they said they had no pain and suffering. So why would there even be an award for them? Now, with regard to Jasmine, they said she had some back pain, and that's what they said, so maybe she can get something for that pain, that 2 days of back pain. So it's true, the word directed verdict was not stated, but I asked on several
But
occasions.
you argued it.
Correct. I argued it. I asked for the court to intervene and dismiss those cases, or those claims. So, and again, I've got 45 seconds. I think we've handled it enough. If there are any questions, I'll answer those. Okay.
See none, thank you. Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. We're going to take a brief recess.